Thank you everyone for joining this BCLA webinar series. And just a quick reminder before we begin, you will have the opportunity to ask questions to our speaker today, Ken, and to do so, just please ask those questions through the Q&A feature at the bottom of your video stream here in Zoom, and we'll get to that throughout and towards the end of the webinar. And so briefly, let me just touch on our event today. Okay, so as you probably know by now, thank you for joining. This is our Bio-Entrepreneurship Seminar Series with BCLA. This is the sixth and final entry of this webinar series, and it's entitled Intellectual Property Protection Strategies. This event was put on both by LA Bioscience Hub and Biotech Connection Los Angeles, who Kathy and I are moderating this event with Ken, who we'll get to in a second. The event sponsors are Pasadena City College, the CNSI at UCLA, and USC Michelson Center Bridge Institute. And of course, we have Ken Funahashi here today, a partner at Wilson Sonsini. And we're really excited to hear from Ken. He's got a wealth of experience in these intellectual property related questions, and has experience in this field. So we're quite interested to learn about that today. And so again, this came out of a partnership with LA Bioscience Hub, and we wanted to just give a special thank you to Jordanos, who's now moved on from the executive director position there, but she really had the original idea here, and we really appreciate her for that. And so just to quickly touch on BCLA, who we are. So Biotech Connection Los Angeles, the main mission is to inspire, educate, and connect emerging scientists and entrepreneurs to grow and diversify biotech in Los Angeles. And we've been doing this now for about 6 years. Our team has grown immensely and obviously has changed over time. Many of us are academics or trainees, and so things change as we develop, but we've always held a strong team. And as a result, we've been able to put on excellent events with many partners, now over 100. And we have thousands of newsletter subscribers who are interested in our events and in networking specifically. So thank you all for joining. If you're not yet a member, please go to our website and check it out and sign up for our email listserv. We only send out 1 email a month, or potentially 2. And then you'll see the rest of our events, which we are hosting all online now, obviously, for the time being. This is just a short list of some of the various companies and organizations that we've partnered with over the years. And so, it just goes to show that we've really kind of developed ourselves as a strong piece of the Los Angeles biotech network. And we hope to continue to do so, not only through continued future events, but also through interacting with you all who are interested in attending our events. And so just to give you a brief overview, we do networking mixers, seminars, and panels. There's a symposia and an annual summit that we hold annually, which is kind of our largest event, which will be in a couple of months from now. Kind of in that late stage, it will be all online, and then as well as an annual career conference. And so just to give you a taste, we've got the upcoming event. Our next event is next week, and it's a partnership with Seismic, and it's called the Speak Bio series. It's on, in this case, a job seeker's guide to talent acquisition, and we've got a panel here who are very excellent and kind of well-versed in this topic. So please feel free to join if you're able. The event information is shown here and also can be found on our website. All right, and with that, I'll end my screen share, and I'll pass things over to Ken, who we're excited to hear from. So welcome everyone, Ken Funahashi, and take it away, Ken. Thank you.
Great. Well, thanks so much, Johnny and Kathy. Thanks for organizing this this seminar, and thanks to Biotech Connection, as well as all of the various sponsors and supporters of the organizations for what you do for the community in life sciences and throughout Southern California. So it's an honor for me to be here. I really want this to be an opportunity for the audience to ask any questions that they may have. I'll provide a brief background of what I do on a day-to-day basis, and then maybe provide some practical pointers about things to consider if you are thinking about starting a company, or thinking about how you can formulate and protect an invention, and then just leave it to Q&A. But by way of background, I'm a partner at Wilson Sonsini in Los Angeles. Wilson Sonsini is a full-service law firm. We really started in Silicon Valley, focused on life sciences and tech, and have been very, very lucky over the past few decades to be a market leader in that regard, helping entrepreneurs and investors as they ideate, to incorporate, to raising their first round of financing, to going public, to then engaging in M&A activities. And so we really focus on a broad range of services to be able to help an entrepreneur who may be a first-time entrepreneur or a serial entrepreneur have all the tools they need to be able to protect their assets, and also to help them grow, particularly for technologies in life sciences and tech, which tend to grow very, very quickly. Some of the companies that we've been really lucky to work with, we took Apple public back in the 80s. We did the Series A for Illumina, and I believe took them public. We've been really lucky to work with companies like NatQuest and NatHealth, and I myself have been very fortunate to work with companies, including very small companies that are just starting to get formed, to very large companies like Pfizer and Celgene and Abbott, in connection with their investment in M&A activities. My practice on a day-to-day basis is corporate. So essentially, I serve as outsourced general counsel to startups that are on a fast growth trajectory, either raising capital or even potentially thinking about going public, and then help them on their day-to-day legal issues that may arise. And that can range from a very broad spectrum to things like the capitalization of the company, commercial contracts, capital raising, and then I have a really great team at Wilson that helps on the IP components. So that those IP components can include patent, licensing, and intellectual property litigation at times. So my practice is more as a generalist, from a generalist perspective, and I bring in the specialists as needed. But as a result, I've had the good fortune to have a broad view of how companies kind of emerge and get started, and some of the considerations that companies may want to evaluate as they're getting started, and considering, ramping up their intellectual property protection. And so, segueing over to the second component, which is IP protection strategies. As I mentioned, I'm a generalist. I'm not a patent practitioner nor a licensing person, but I work very closely, almost daily, with the teams. Just had a call actually before this on a collaboration agreement involving both a financing component and a IP licensing component. And so let's just say that for those who are on the call today or the video conference today, you're a first-time entrepreneur thinking about getting your company started. Now, there's an interesting distinction that's becoming more and more blurry that we've seen over the past few decades between classic life sciences and classic tech, where life sciences have typically been very, very patent heavy. You're either trying to find protection for a small molecule, you have an innovative diagnostic that you're trying to get protection on, but the patent landscape for life sciences is very crowded because there are very, very large players involved. And as a result, the ability of small companies to try to protect what they're developing becomes more and more paramount. In fact, many financings are predicated not necessarily on the cash flow of a life sciences company, because it can be many, many years before a company, let's say in therapeutics, can become cash flow positive, but rather the strength of their IP portfolio and their team. Juxtapose that against tech, where historically, and this is actually more the case now, you could have a group of founders, technical founders, build a product, and that product could be built in a matter of months, sometimes in a matter of weeks, and they can release it out into the marketplace and get validation. And that validation can either occur through a combination of revenue. So for example, Google and Facebook get revenue primarily from their advertising. It can be a function of subscription based. SaaS software, for example, and so forth. You'd go out, you'd develop a product, sell it, and then start to generate revenue off of that. Or it could be a platform technology, or rather a a media play where you're trying to get eyeballs and you're using get that user engagement, similar to Facebook and Google and some other platforms, to be able to create what are called monthly active users who look at the website and want to engage. And the longer they engage, the more helpful it is for advertisers to sense where they want to put their advertising dollars. So for tech, it's actually relatively, the pathway to revenue positive is much more, usually is faster than in life sciences, where it can take many, many years to conduct the research and development, B, to pursue a clinical validation of the business thesis, and 3, to clear regulatory approvals associated with the product, because we're talking about life and death and human health. The regulatory overlay on life sciences tends to be greater than let's say a software company, and so as a result, going back to the first observation, protection of intellectual property becomes very paramount, because in many senses that's the way in which a small company can protect itself against large companies, to be able to create their own fence around their technology, so that they can continue to develop that technology and not have to worry about others potentially infringing on or acquiring or copying or reverse engineering their technology. And B, it's a way to establish to prospective investors and to strategic partners that there's a certain period of time by which other parties cannot use that technology without having to first get a license from or acquire that patentable technology from the owner. And so so for life sciences, IP becomes mission critical, even from day one. And day one can even be, maybe day -1, where let's say you have a postdoc or a professor who is working at a university or a nonprofit organization, and has come up with a really innovative type of technology. So even at that point in time, let's just say that professor or postdoc or employee has come up with something really innovative, but he or she has done that using lab resources, of the university, using personnel of that university, etc. Generally speaking, most universities will have very specific protocols on what that individual has to disclose to the university in terms of inventions that are developed during the course of employment or using university facilities. And then number 2, who actually owns that technology. And so the first step, even before creating a company, is for those individuals who are affiliated with universities or other types of organizations where IP is generated. The first step is reviewing the policies, procedures, and sometimes the agreements that individual is subject to. Now, the good news is that for universities like the UC system and others, there's a very well-trodden pathway to facilitate an individual looking at an invention that he or she has developed and determining who owns that invention, and then also secondly, to the extent that that individual wants to then create their own company, there's a reference that many of you may have heard about, a technology transfer office. And so many universities have what are called tech transfer offices that focus on the ability of individuals, whether within the university or sometimes even outside of the university, to look at promising technologies that have been developed within the 4 walls of the university, and either buy that technology, license it, or acquire an option to license or buy it at some point in the future. Because, and tech transfer offices, some of them have very, very specific protocols and procedures and agreements that they will kind of provide to that individual should they express an interest. And that has helped kind of accelerate the the ability of the startup ecosystem here in Southern California and elsewhere to be able to have some kind of roadmap where the technology that may be developed outside the university can then be licensed to or acquired by a for-profit startup, and that for-profit startup can then raise money to try to commercialize that technology. The university or whoever has ownership of that technology, typically it's a win-win for them, because they will sometimes either A, get an upfront payment, B, get back-end payments associated with royalties, C, get their costs covered, or D, sometimes get equity in the startup, and so they get to get the upside of whatever that for-profit spin out is able to generate from a valuation perspective. And so when I say step negative one, these are things that actually an entrepreneur may want to consider even before they incorporate, because it may be that if they incorporate thinking they own the technology, and then later an investor comes to the table and says, wait a second, actually, wasn't this technology developed while you were at the university? And that entrepreneur hasn't gone through the steps of evaluating his or her own, agreements, policies, and procedures, and or negotiated a tech transfer license from that university. Then the investor may have a very different feeling about their willingness to invest, because the university could turn back to the entrepreneur and say, well, you actually haven't done steps A, B, and C, so therefore the for-profit that you created, the IP that you developed, really isn't owned by the for-profit, and that may have a chilling effect on an investor unless the entrepreneur is able to explain and distinguish their IP from what was developed during the university. Similarly, even after a startup is established, it's not unusual to have an ongoing relationship between the entrepreneur, the startup, and the university in which they work, and that is through either having agreements in place between the startup and the university, where maybe the startup engages the services of personnel at the university or lab facilities at the university to be able to defray some of the costs of having to hire full-time people for their startup and or buying their own lab equipment. And so those agreements as well, particularly with the UC systems and Southern California companies that are focused on life sciences, rather Southern California universities focused on life sciences, there's also a well-trodden pathway to have specific agreements that define how personnel can be used, university personnel can be used with a startup, who owns the intellectual property associated with the IP that's generated as a result of those services, and so forth. And so that's the nice thing about Southern California, is that because it's such a hub of innovation, universities have been very, very progressive in terms of trying to help entrepreneurs, create companies and pursue their vision and dreams. And that was also driven in part by very entrepreneurial professors at these universities who, have joined these universities not only for the ability to provide great education and conduct research, but also for the opportunity to maybe take a break and or develop IP that can then be licensed or developed by startups, and therefore have kind of have one foot in academia and then one foot in entrepreneurialism as well. So that's, generally speaking, one of the things to consider, particularly for individuals who are affiliated with the university or nonprofit, is to kind of look at what the policies and procedures and agreements are in place with them, and then also evaluate after the individual wants to start up a startup, what additional services or personnel may be needed, to get that startup, on its own feet, so to speak. So that's step negative one. Step one then becomes, okay, now that pathway has been negotiated, has been navigated. There's been negotiations with the tech transfer office or the university, and everything's ready to go, either through a license of the technology, an option, or an acquisition of the underlying IP that the entrepreneur wants to develop and commercialize. At that point, then the entrepreneur has a choice, which is to say they can either remain as an individual and and run their business. Or more typically, that entrepreneur will create an entity. And then what that entity does is it provides that entrepreneur limited liability protection and also a vehicle in which they can receive investment. And so that entity is generally speaking, you may have heard this before, that they're called corporations or they're called limited liability companies. For venture track businesses, generally speaking, you see what are called Delaware C Corps being used because they're very, very friendly mechanisms to attract venture capital and ultimately an IPO exit. Although there are advantages of using limited liability companies as well in the alternative. And LLCs can always convert at a later point into a corporation if a VC requires that to be the case. And so let's just say an entrepreneur goes out, wants to set up a company, and has a decision to make as to whether to start up a corp or start up an LLC. That's where typically the entrepreneur will bring me into the fold, and then we go through the pros and cons of those types of structures, and then help set up the organization. Now, it is tempting to use online services, and I think that there are certain circumstances where using online services can be helpful or expedite the formation or potentially reduce cost. Having said that, though, we've seen so many cases where an online service is used and it's incomplete documentation. And it's incomplete documentation, and this is just a reminder for anyone who may have used an online service and has started their company from a couple of perspectives. But that can be fixable. The first is what's called capitalization of the company. Now, let's say an entrepreneur wants to start up a company, and they want to bring in other co-founders, or they want to bring other people to receive equity to motivate to motivate others to work with the company, with the startup, and everyone kind of benefits from the rise in valuation. If that capitalization isn't spelled out essentially from day one of the co-founders, the employees joining, it can be very, very difficult to correct after the fact, because as the company grows in value, then the underlying stock or the promises for stock, the value of that stock or the promises increase in value. If it isn't done right in the beginning, it can be very, very difficult to try to correct it after the fact, either because of the tax consequences that could arise, or potentially that there could be disputes as to who actually owns what percentage of the company is owned by so-and-so party, right? So that's the first thing to consider, that sometimes isn't always outlined in online services. And something that that an entrepreneur will want to have a mental map of before they start the company, because it can become a very, very big issue in the context of a venture capital raise, an IPO, or an M&A. The second of which is that it's very important, particularly for life sciences companies, to ensure that employees or consultants have assigned intellectual property that they develop on behalf of the company to the company. And that's usually done, through what many of you may have heard of as confidential information and invention assignment agreements, CIIAs, or PIIAs, which is proprietary information. And what those do basically is they say, okay, if someone is joining the company either for equity or for cash services, then there's a baseline expectation that in exchange for the equity or in exchange for the cash, that particular employee or consultant anything they develop on behalf of the company will be owned by the company. And so in the absence of that agreement, there can be significant confusion over actually who owns the intellectual property. Let's say if an entrepreneur hires a consultant, that consultant develops something very novel relative to the technology that they're developing, then there can be problems, particularly when investors come to the table where they're saying, well, wait a second, this consultant never actually signed a proprietary information agreement, so how do we know that the company actually owns that intellectual property developed by the consultant? So that's a second component that can be very important in the context of just getting the company started. I think the third thing that sometimes arises as well is that life sciences companies will oftentimes reach out to suppliers, to vendors, and other strategic partners to either obtain supplies, to to get some research and development done, or to outsource some of their operations. And again, the same issue applies, which is who actually owns the IP that is generated as a result of these outside consultants or outside parties. Let's just say the supplier, the company or the entrepreneur tells the supplier, hey, can you create a particular product that with these particular specifications? And it takes the supplier some time to develop it, but it's unclear as to, okay, well, is that now supplier IP or is that the company IP because the company told them to do it a certain way? So having agreements in place that define the relationship and the IP ownership between these third parties and the company is important in the same way as defining the relationship between an employee and a consultant, an independent contractor and the company. I think the fourth area to consider as well from day one is to consider whether or not it makes sense to file IP. Now, one of the challenges associated with startups is cash considerations, right? That it is that many times entrepreneurs will be bootstrapping. And it's very difficult when they're looking at their budget to say, okay, well, I need to allocate this much to patent work. I need to allocate, this much to operations or research and development or personnel. And so with life sciences companies, I think the challenge is that, that because IP tends to be mission critical in terms of valuation, in terms of being able to protect the company from competition, that sometimes it's a challenge to try to justify the cost of filing for patents. So the good news is that that there are mechanisms to kind of defray the costs associated with patent analysis and patent protection. Maybe the most common of which is called a provisional patent. And a provisional patent basically is a patent that holds a place in line for up to a year from when the provisional is filed. And it's not a full patent. It doesn't give you the protection of a full patent, but it basically creates a priority date in which the entrepreneur can say, hey, this invention that I'm describing in the provisional patent, this is the date in which the entrepreneur or the company has deemed that to be invented by themselves. And so it gives a year runway for the company to further commercialize the technology, develop it, maybe bring in some investors who can then fund the cost of a full patent in the US and other countries that, where either the company or the investors want to get further protection on. And so a provisional can be a good way of kind of staging out the cost associated with, pursuing a patent strategy. Similarly, there are law firms like ours that will potentially do deferrals of fees for a limited period of time to be able to let that company, develop the technology, get a provisional on file, and then raise funds to try to further commercialize that technology. So that's a fourth consideration to evaluate in connection with starting the company from day one. Obviously this is not an exclusive list of things to consider associated with forming a company, but particularly in the area of life sciences, one of those four, they tend to be some of the key pillars associated with a startup. Now let's say that the first step, or the -1 step of determining the relationship between the university and the entrepreneur has been decided. The company is set up. Appropriate agreements have been put in place for capitalization, IP ownership. Suppliers and key strategic partners agreements are in place, and let's just say that they've applied for provisional. Now the question becomes, okay, how does that company raise money? That's one thing. It can be very challenging because it can be a chicken and the egg where an investor will come to the table and they'll say, okay, well, you're a first-time entrepreneur, so we don't, we really need to see validation before money gets put into the door of the company. And that can be true even of multiple serial entrepreneurs as well. And so what we've seen occur is life sciences companies can apply for grants, and sometimes those grants they're nice because they're non-dilutive from the perspective of equity. they do take a long time to apply for and receive. And there are certain parameters and restrictions around, what those grants can provide and what the company can do with the money. But they're a very helpful mechanism to sometimes accelerate the pathway of commercialization for a life sciences company. The second is, it is possible to get a group of angels to consider investing in the technology. Generally speaking, to get angels interested in the technology, the four pillars described in the startup, plus the -1 step, which is having everything cleaned up with the university. That's a prerequisite for angel investors to consider investing in the company. Not always. I mean, sometimes it's friends and family, and they don't engage in as rigorous of due diligence. But generally speaking, that's the expectation. In addition to those steps that I just described, the question then becomes for an angel investor is, how do we know that this technology, A, is going to work, B, is going to be better than what is already out in the market or is being developed by other well-funded competitors, and so from that perspective, it's sometimes helpful for that startup, the entrepreneur, to not only certainly justify the value of their technology that they're developing based on their own thesis and their own vision, but also to surround themselves with experts in the field, whether it's professors or whether it's people in the industry who have looked at the technology, understand the field deeply, and basically validate that entrepreneur's vision and says, yeah, we looked at other companies in that field, but we really like this particular entrepreneur's vision. And the way in which that can be manifested in the context of life sciences and other industries is by establishing what's called like a scientific advisory board. And you may have heard this as well, where an entrepreneur will have their core team of them, their co-founders and some key employees. And then they'll have advisors that are called scientific advisory board members that will only provide a limited amount of service on a monthly or quarterly basis, sometimes in exchange for either cash and or equity. But that scientific advisory board is there to help guide the entrepreneur through their journey, but also B, serve as a sounding board, for both the entrepreneur and also prospective investors. So it's not unusual to have scientific advisory board members be from academia, because they just know the particular field of the field very, very deeply and very, very well. And it can be people from industry. It could be people previously affiliated with companies that have engaged in the similar type of technology as the founder. Sometimes they can be investors themselves that are just angel investors in the life sciences field. But that validation component, either through grants or through people very, very familiar with the technology in the industry, can be helpful to catalyze the next round or the next stage or the next step of the company's evolution as they start to attract third-party financing. Then, and this is not necessarily, there's no magic order to this, but after a certain point in time, once the company has kind of developed their technology to the point where, they are now undertaking regulatory trials and clinical trials and regulatory review, the capital expenditures to take the technology even further become higher and higher. At that point in time, the entrepreneur may want to consider getting what's called venture capital. Now, venture capital are professional investors that are VCs, institutions as opposed to individual angels that make a living investing in companies that they believe will provide, a significant return on investment to their limited partners, who are the investors in the venture capital firms. And so you've seen different models in life sciences VCs. Some life sciences VCs like to invest very early on in a company's growth, with the theory being the valuations are lower, they can have more say in the company. Typically speaking, their ownership percentage is higher, and they'll back entrepreneurs who either have just remarkable domain expertise, or maybe, it's a serial entrepreneur. Other VCs will kind of wait and wait to see if certain critical milestones from a commercialization, research and development, and regulatory perspective have been obtained before they put their money in. And so there's a wide spectrum of VCs in the life sciences community, depending upon the industry, depending upon the geographic region, et cetera. The nice thing about Southern California is that because Southern California is such a hub for life sciences, VCs from all around the US and all around the world tend to have a very close eye on what's happening in Southern California. And that can include VCs from Northern California, from Boston, from Asia, from Europe, et cetera. So, it's just a process, and sometimes a slow process of identifying who the right fit would be, to the extent that a company wants to pursue venture capital. And so, and thereafter, I think, the company will, after raising venture, typically speaking, the exit for most life sciences companies is a sale to a strategic. Strategic is generally referred to as a large company that wants to buy the technology, as opposed to, taking the company public. Although we have seen, a very healthy activity in the life sciences IPO market this year and in recent years. By and large, where founders and investors get most of their liquidity is through an exit to a large company, a large pharmaceutical company, diagnostics company, you name it. So, so that's in kind of very broad strokes the life cycle of a life sciences company, and some of the things to consider, for an entrepreneur who may be thinking about, starting their first company or commercializing some of their technology. But with that, I'd be very happy to address any questions that either of you have, or that any of the audience members have.
All right, excellent.
Yeah, so we've been getting quite a few questions from the audience. We're going to try our best to address all of them. Let's start with the first one. So someone was wondering basically how you can use UC lab facilities, but keep the data that you get as a part of a startup. Specifically, is a materials transfer agreement necessary before starting the research to retain the data ownership?
Yeah, good question. And that goes to the earlier point, which is, understand the kind of the negative one step, which is to understand, what obligations does that particular entrepreneur have to the university, currently, right? Because it may be that the university actually owns the intellectual property. And so that entrepreneur then needs to negotiate a license or an option or an acquisition of that underlying IP. And that would, let's just call that core IP, right? Then, assuming that that issue has been navigated, then it leads us to that step one, which is starting the company off. And I think that the individual has asked the right question, which is, okay, let's just say that they've now started the company. They've resolved the issue of the tech transfer out of the university relative to the core IP that was developed under the auspices of the university facilities and personnel. Now but they still want to continue using the university for various services or various expertise. And there, that's really negotiated on a case-by-case basis. It can be through what's called the material transfer agreement. It can be through an SRA, a strategic research agreement. There are different mechanisms by which a company or an entrepreneur can negotiate with the university for intellectual property that will be further developed outside of through the company, but using your university personnel and or facilities. And so all of it tends to be case by case. So for example, it really depends on the pricing. Sometimes it depends on the pricing of what the university is going to charge. Sometimes the university will want publication rights. I mean, there are different ways that those agreements can be negotiated, but it's all going to be a function of price, ownership of intellectual property, some ability of the university to be able to use that IP for their own purposes, for publication purposes, for internal research purposes, that kind of thing. But those can be negotiated on a case-by-case basis. And the nice thing, for many of the Southern California universities is that they have their own forms. They tend to be, pretty, standard. I'd say that outside of California, there are universities where you really have to address these issues on a bespoke basis, and it can be a longer process and a more complicated process. But the nice thing about California universities by and large is that they're very progressive and proactive in trying to understand the entrepreneur's needs and crafting an agreement that accomplishes the objectives. But the overriding principle behind this is that if at all possible, you want to make sure that the IP that's generated is owned by the company, because that's what drives the value of the company. So the more IP that can be generated by the company and owned by the company outside of any third party, the better it is typically for that company.
Excellent. Thank you for that information. We actually have a related question, which I'll go ahead and ask now, which is how long might a university own the tech or part of the tech of a startup that started at the university? And as you mentioned, I'm sure that this varies on a case-by-case basis, but maybe you could give us a feel for that range.
Oh, sure. And the question was, how long does the university...
how long are they involved in the ownership over the IP or the technology of a startup that originated at the university?
Yeah, you're absolutely right. That's negotiated on a case-by-case basis. So for example, it may be that some universities may not want to give that IP right to an entrepreneur, and sometimes it's a function that that entrepreneur has been at the university but is part of a larger team that is collaboratively and jointly developed that technology, and let's just say that even though that individual wants to go out and commercialize the technology, the university may say, well, wait a second, well, the professor who actually had a very large role in developing that technology doesn't want to license it out at this point in time, right? So it's really a function of, okay, what are the right dynamics by which a tech transfer can occur to a for-profit entity? Assuming that that tech transfer can occur to a for-profit entity, then the question becomes, what does the agreement provide, to your point, Johnny, in terms of, is it an option to license the technology? Is it a license agreement itself? Is it or is it an outright acquisition of the underlying technology? And so, naturally speaking, that's along the spectrum. An option means that you're gonna have to work with the university for some period of time. Usually options are used where an entrepreneur says, they either don't have the funds to pay the upfront to the university at that time, and they want to have an option maybe with a lesser amount of money to be able to, to at least block others from grabbing that technology. And so at that point in time, just to exercise the option and then negotiate a license agreement, you're going to be working with that university for the duration of that period at least. Then on the license piece, let's just say that covers core technology. You're going to have to negotiate a license with that university, and then the specifics of the terms of that license will provide the amount of interaction that's necessary with the university, because maybe it's just core IP that, and then the entrepreneur will say, okay, I just need the core IP, but I'm going to develop everything else needed to commercialize outside of the university without reliance upon the university personnel or facilities, and so therefore, I really just need the university to provide this license of the core IP, so that it's so that foundational IP can be then used for the incremental IP or the independently developed IP of the company. But oftentimes, the entrepreneur will say, well, actually, we need the core IP, but the professor who has helped develop that IP is still at the university, so they're still going to keep developing that IP at the university. So that license has to address, okay, not only the core IP at the time that the license is signed, but also any additional IP that may be developed during the course of whoever's left at the university developing, a similar IP or just an extension of that IP. So if that's the case, then, to answer the question, it usually involves a longer term relationship with the university, particularly the faculty members or the researchers at the university who continue to develop that underlying IP or enhancements or derivatives of that IP. And the third scenario is an outright acquisition of the IP. And there, generally speaking, that's a little bit easier where you're just outright buying the IP from the university. But even then, I mean, there are situations where professors, postdocs will buy the IP, but they'll either stay with the IP or they'll have team members that are still, they'll either stay with the university or have team members who remain at the university, and you still have to negotiate this process. So, it's a balance. It really is a balance, and it's going to be a function of, who's part of your team, what are the university personnel and facilities that the startup will still continue to need to use going forward, and then how much funding does the startup have to be able to develop independent IP that is completely separate from university resources and personnel.
Well, thank you. I hope that answers the question. We have sort of a follow-up question to that about sort of the time when the researcher should start considering licensing the IP. So should you start researching with that in mind, or is that something that you should do at the end when your project is finalized?
That's a good question. I mean, that really has to be assessed on a case-by-case basis because, at the end of the day, a researcher at a university, is usually part of a team. It's really going to be driven by the team dynamics as to, okay, if the researcher comes in and says, okay, I want to work with this technology that's been developed by the university, but I want to own everything because I'm going to take it to a startup, that may not necessarily create the dynamic, to facilitate an acceleration of the research and development amongst the team members, right? Whereas if it's, okay, hey, the four of us, develop this IP completely within the university, but the four of us want to become co-founders in a startup, and one of those co-founders happens to be like the university professor or something like that, right? Then even from a tech transfer office perspective, it tends to have a different flavor, right? Because it's something that is benefiting the university as a whole, is benefiting the entrepreneur group, including the professor and so forth. And so it really has to be assessed on a case-by-case basis. I think that, for research, for someone engaging in research, if they are engaging in research completely unrelated to what they're doing at the university, and they don't use any university resources, any university personnel, right? It's all IP that they have developed on their own laptop, with their own time, on their, with their own resources. Then the more of a separation that can be created relative to what their role is at the university and what their technology is that they want to own independently, the more favorable the facts are. It's not necessarily a slam dunk case, but it has to be assessed on a case-by-case basis.
Right, excellent, thank you. And we have another question from the audience is, if technology is published in a journal, is it considered as open source, and can it be, if so, are any limitations on that?
Yeah, on this I'm going to have to refer to my patent colleagues, but in general, I think that once an invention is out in the public domain, it definitely impacts the ability to patent the technology. And so, and it's a fine balance, right? Because it's kind of not a tension, but a dynamic that occurs between a university or even faculty members of the university who want to publish, right? And want to publish innovative technology in journals, that distinguish the university and the faculty members against, the patentability of what's being disclosed in those journals. And so, and the effect of publication in a public resource, and the effect of the ability to patent what's actually being disclosed in that journal. So the good news is there are ways to navigate through that. I'd mentioned, like, in the context of some of the agreements, that sometimes universities will want to retain publication rights. And so, there are ways to navigate through those waters. Sometimes, you can sequence the timing out. You can have a review process, that provides the entrepreneur some ability to file for patents or provisionals before the the publication is actually published. But that, again, it depends really upon, that particular, institution. It depends on the entrepreneur. It depends upon what's actually being disclosed in the journal.
All right, thank you. So someone was wondering if you have any advice on getting grants for startups that are still in the research phase. I was wondering if you could, if you had any helpful tips for that.
Actually, it's an area that I don't touch upon that much. On the corporate side, and so, yeah, I mean, I have to defer on that question. I would probably say that, I would have a couple of recommendations. The first of which is to canvas, the eligible grant universe as thoroughly as possible, because, applying, the more grants that are applied for, the higher the probability of success. The second of which is, for the community that he or she is involved in, just try to get input from other people who have successfully applied for grants, and to get a sense of, okay, not only, are they approaching the right universe of institutions that will allow grants, but also what's the best way to write the grant in a manner that increases the probability of success.
Great, thank you. And back to the IP, maybe a little bit more in your comfort zone, but we do appreciate you reaching out beyond what you do in your day-to-day as well. But in terms of digital therapeutics, how might the IP strategy differ compared with more traditional therapeutics?
Yep. Again, as I mentioned in the beginning of the call, I'm more of a corporate generalist, right? So in terms of identifying the distinctions between digital therapeutics and classic therapeutics, it depends, right? We really have to get a patent person to look at the technology, have an assessment of, okay, are there components of that technology for which there can be patent claims constructed? And to me, that's on a case-by-case basis. If the question, on the other hand, is maybe it's a digital health play or a telemedicine play, right? To me, that's a different bucket than a therapeutic play, because digital health, is a very complicated technology, but sometimes the foundational components of digital health are predicated upon technologies that already exist, right? Whether it's telecommunications, whether it's database, database sorting, whether it's EMR analysis and that kind of thing. And so those, to me, are different buckets than for example, trying to look at a small molecule. I do think that we're entering into a really interesting phase now, where on the genomic side, we're getting to a point where we can read DNA, pretty well, and the cost of reading that DNA is going down, and so that may open up a very interesting industry where where the analysis of that DNA and the tools, the digital tools that will help facilitate that analysis, may become more and more widely disseminated or widely accessible, and that's a very exciting area, right, for purposes of drug discovery, disease prevention, etc. To me, I think an evaluation of the distinction between digital therapeutics and classic therapeutics would really necessitate an understanding of the underlying technology, because the construction of the claims are so fact specific.
Thank you. I think we have time for one more question before we run out of time. Someone was wondering if your employer is financially helping you obtain a higher degree and you begin research at university facilities while you're still under contract with the business, how is the ownership of the IP negotiated between the three parties, that being you, the business, and the university?
Yeah, great question. So in part, it's going to be driven by a couple of factors. The first of which is, what is the technology that the individual wants to commercialize, independent of the employer or the university, right? And so that, the closer it is to what he or she is doing at the employer or at the university, the more scrutiny is going to be applied relative to what ownership rights does the employer or the university have. The second then becomes kind of the earlier reference, which is what does that individual, what facilities, resources, and personnel does that individual use from the employer or the university to be able to develop that technology that he or she is thinking of developing, right? And so the more reliance that that individual has on the facilities, resources, and personnel of the employer, as well as the university, the more difficult it is to create a distinction that's somehow independently developed. I think the third thing is, similar to what we had discussed in the context of university policies and procedures and agreements, which define, what IP is owned by the university and what IP is not. Employers also have their policies, procedures, and agreements that define what can be owned by the employer and what is not. And we had talked about, I think earlier, step one, which is setting up the entrepreneur's own company, getting what are called proprietary information agreements in place or confidential information agreements in place. And for tech companies or life sciences companies, there's probably a higher probability that an employer who is putting someone through school for the purposes of being able to come back and help the employer take their technology to the next level, chances are that it's probably touching on technology and or science. And so there's a higher probability that that individual has signed agreements with the employer addressing the ownership of intellectual property already, right? So then it becomes an issue of, looking at those agreements, determining what is owned by the employer, looking at the university, determining what is, what the university policies are, and then, making an assessment as to, is this something that the entrepreneur has to get either permission from or license from the employer and or the university to be able to do their own thing. Sometimes it works. I mean, there are companies that we work with where an employee is talks to the employer and says, look, I developed this thing, and it did require employer resources and it did require employer facilities, but it's a separate thing. It's non-competitive. It's something that that we think we can create a separate company for. And we've seen scenarios where the employer will say, okay, well, go ahead and do your own thing, but can we either get equity in your new company, or can we invest in your new company, or can we get a license to some of the technology that you're developing associated with the new company? So it's all going to be a function of negotiation. If the agreements provide that the employer and or the university have some rights to the inventions.
All right.
Well, yeah, thank you so much, Ken, for joining us. I found this session to be quite informative, and I'm sure many in the audience agree. And so before everyone takes off, I just wanted to, again, send our thanks to Ken and our appreciation to the audience members for joining this event, which we co-hosted. And by we, I mean BCLA. The whole team has put in a lot of effort here, along with LABH, LA Bioscience Hub. So thank you again to all of you who have attended. I will stick around, and feel free to send me a quick chat or Q&A. Well, I guess I might prefer the chat. I'll stick around in case there's any follow-up questions afterwards, but is there anything, Kathy or Ken, you wanted to touch on before everyone takes off?
Again, thank you for everyone who attended, and thank you for submitting your questions. Thank you, Ken, again.
Yeah, we hope to see you at the next event, everybody.
My pleasure. Looking forward to it. Thank you, everyone.
Thank you.
Thank you.